When I first watched this hearing, I thought, some interesting motions. Then I realized the backstory was way more interesting. So this is B.J. Brown. He lived in New Orleans with his on-again, off-again girlfriend, Cassandra Jones. She's shown here, beautiful woman with her 3 beautiful daughters. They had a tumultuous relationship. She filed a restraining order in the past, but didn't show up to court to finalize it.
Fox 8 has obtained a copy of the 25-page temporary restraining order Jones filed in May. It alleges Brown punched, choked, shoved, kicked, threatened, intimidated, and sexually abused her, along with mental, emotional, and financial abuse. It details an early morning incident, April 27th, around 3:30, when Brown allegedly came over and they began to fight. Jones says she told him to get out, and he hit her with a belt several times, bruising her. 911 was called, and Jones says Brown punched her and threw her to the ground, stomping on her. Once police arrived, she says Brown jumped off of her upstairs balcony to escape. After the officers left, she says he got back into her apartment, where they continued to fight, and he tried to smother her with a pillow. She also alleged there was another occasion where she confronted him about cheating on her, and he punched her, knocking her teeth out. However, Jones never showed up to court to follow through with the restraining order.
She worked for the clerk of courts, and the story of how she got the job is pretty awesome.
First City Court Clerk Austin Baudon hired Jones about a year ago. He met her when she was seeking emergency rental assistance, but what she really wanted was a job, and he saw her potential.
We sat and we talked, and she had the attributes that I was looking for. She had the computer skills, she had people skills, and I saw somebody who was looking not for a handout, they wanted to work.
The morning of the incident, Cassandra was in the parking lot near her car getting ready to leave for work. Around the same time, a resident in a second-floor apartment heard what he thought was a gunshot. He looked out the window and saw a man walking across the parking lot with a gun in his hand. He started filming on his cell phone. He saw the man walk across the parking lot to a woman who was lying on the ground, already shot in the back, and shoot her 2 more times. I'm not sure if he called the police immediately, but he uploaded the video to social media, and of course, it went viral.
Right now, the search continues for a man New Orleans police say shot and killed a woman on Iberville Street, then drove to Middle Tennessee.
After the incident, Jones traveled from New Orleans straight up to Tennessee, about 500 miles away. It was there that an officer tried to pull him over.
Then Monday night, that's when Brown was pulled over just off 149 here in Erin for a traffic stop. Now, we obtained this surveillance video where you can see Brown firing several shots at an Erin police officer while the officer was still in his patrol car. The officer also firing back shots as Brown runs away with his handgun. That's the last time we saw him on camera.
So then the manhunt ensued across the state of Tennessee.
We will not rest until he's captured, justice is served, whether it be by a jury or Jesus.
This is the first time we've experienced this within our department. We're a 6-man department.
Erin Police Chief Mark Moore said Brown ran into the woods after the shooting. A 30-plus hour statewide manhunt led to Brown's arrest early Wednesday morning in Tennessee.
I'm overjoyed.
And I'm not surprised he would open fire on a police officer.
Brown is no stranger to St. John the Baptist Parish Sheriff Mike Trigg. He says since 2010, his deputies have arrested Brown more than 15 times for crimes involving drugs, weapons, and high-speed pursuit.
This hearing that we're going to look at, Jones is facing the attempted murder charge of the police officer. They're trying to rush the hearing and get it done as soon as possible so that they can transport him back to New Orleans so he can answer for his crimes there. And the family of Cassandra Jones can finally get justice.
Said in a statement, Cassandra was a vibrant lady who was loved by many people. She had a personality that would definitely light up a room. Our hearts have been ripped apart. She meant the world to us.
So this is the motion hearing in the B.J. Brown case in front of Judge David Wolff.
All right, this is the state of Tennessee versus B.J. Brown. It is a Houston County case originating in the Circuit Court of Houston County, where the defendant is charged with attempted first-degree murder. The parties, by agreement, have transferred venue to Dixon County, Tennessee, and we are now set for trial on Thursday of this week. And the defense has filed a number of different motions. So, Mr. Spratt, we're going to let you take them up in the order that you filed them.
Yes, sir.
I think some of these are not contested from what I understand.
Right, Judge, which would probably necessitate me going a little bit out of order.
That's right.
Motion number 5, I filed motions 4, 5, 6, 7, and 8. Motion number 5 is a motion to have the case declared extended and complex. The state has no issue with that motion. I would just ask that the court allow me, based on the allegations in the motion, to submit an order of finding of undue hardship and extended and complex under the rule for funding on that.
I don't have a problem with declaring it extended and complex.
Okay. So that would take care of number 5. Number 6, right. Number 6, Judge, when we litigate motion number 4 shortly, motions 6 and 7 were filed in a direct response to the motion number 4 with the PowerPoint, but the state has said again that they do not plan to call any witnesses from the U.S. Marshals or the New Orleans Police Department in this case. There's a standing order from this court that was agreed to by the state to not reference anything that happened in New Orleans. So when I got the piece of what they call evidence that triggered me to file motion number 4, I then filed motions 6 and 7.
And your motions were based upon the fact that the PowerPoint presentation that was presented to you by the state had reference to events occurring in Louisiana and the defendant's location, and it also referenced a crime scene there where I think the defendant was maybe charged or is at least accused of a murder in Louisiana.
That's correct, Your Honor. And from my understanding, they're agreeing to motions 6 and 7.
I want to clarify that obviously if they're using a PowerPoint showing his movements, then I want to hear from the state about what their intentions are. I mean, I understand they're not intending to use the evidence of witnesses or police department, but if they're going to use the PowerPoint, we need to kind of figure out what we're going to do about that. So let me hear from Mr. Crouch or Mr. Turnbow about that particular point.
Judge, if I may briefly say something about that before they respond. That does say crime scene right there in the middle of the PowerPoint, but I don't understand the relevance of his movements up until the time of the events that are alleged to have occurred in Houston County, just under a general relevance objection, as well as a potential 403. And the venue's been moved in this case once. I think any reference to another state is just asking to make it hard to pick a jury or have an impartial jury. So
wait a minute, you think just the evidence that he was coming from another state would make it hard to get an impartial jury?
Well, I just don't, I mean, there was some news coverage of this case, and I don't see the relevance to it at all. This is alleged to have occurred as a traffic stop in Houston County. It went about a quarter of a mile, maybe a half a mile, I'm not sure. But that's when everything that he stands accused of in this indictment occurred right there in Houston County. And one of the slides in the PowerPoint triangulates a cell phone as to being at that scene. I certainly think that would be fair game. But I just don't see any need to track that. He's not accused of anything criminally in this state that backs up any farther than that. So I just don't see the relevance in it and the danger of unfair prejudice. I mean, it could easily trigger some memories of news coverage of the case and potentially cause a mistrial or any number of things. So it's not necessary. It's not relevant to any element of any offense that he's charged with here. It's not even remotely relevant to any of it. So
you're arguing your motion without me hearing from the state as to whether or not they agree with you on everything.
They don't agree with me on motion 4. I'm fairly certain. So I'll yield.
Mr. Crouch, Mr.
Judge, which motion am I arguing? There's several here. I'm going to start with number 4 because that addresses the PowerPoint specifically. What the state intends to offer is a PowerPoint that charts the pings on the defendant's cell phone as he leaves New Orleans and drives to Erin, Tennessee. Now, Mr. Sprout was correct. When Agent Valley initially prepared the PowerPoint, he did identify a location in New Orleans as, quote, crime scene. We have removed that from the PowerPoint. We do not intend to have the words crime scene in New Orleans. It's simply a charted plot of all the locations of Mr. Brown as he was driving to Houston County. Here's why that's important and relevant. One, Mr. Spratt said this was simply a traffic stop. But that's not exactly how it went down. There was a traffic stop and then a 2-day manhunt for an unknown person because he was driving in a car that was registered and owned by somebody else. So we didn't have the identity of the person that shot Officer Tieber during the actual manhunt and directly after the shooting. So one, it goes to the identity of the defendant, the person responsible for this crime. 2, it goes to his location and apprehension. I mean, they charted this cell phone to see where he is at the time and where he might be going. And then finally, it goes to the corroboration of his confession, of parts of his confession, and also to show some of the lies that he told in his confession. So it's, all of the legal issues that Mr. Spratt raises, 401, 402, and 403, are satisfied based on what we intend to show at trial. That is the PowerPoint issue. But let me show the court, if I may, in part of my argument, the video that Mr. Spratt is referring to.
May I ask to clarify which video he's asking to show?
So Mr. Spratt is referring to a crime scene location, and we're going to show the video that he mentions in his motion of this homicide that occurred in New Orleans.
Judge,
it's a 10-second clip.
Judge, I object to this if this needs to be taken off YouTube if we're going to do this. I object. If he's going to show what I think he's going to show.
Well, that's the point of this hearing, Judge.
He can show whatever I allow him to show. But what I don't know is what is this particular thing. And number 2, this is a public proceeding, and that's the reason that we live stream these things. Anyone who is called as a juror in this case will be questioned about whether they have read or seen or heard anything about this case prior to the time they're called as a juror. And as a result of that, I don't think there is any basis for, we hear pretrial motions all the time. The different courts handle it differently. What exactly is the video you're wanting to show?
This is a video that is obtained by cell phone of a resident of a location on Iberville Street in New Orleans. He is on the 2nd or 3rd floor in his apartment, and he films the defendant walking down a sidewalk wearing a pair of orange tennis shoes that are recovered in Houston County, in Erin, Tennessee, in a shed, and a rifle that appears to be, and after testing is confirmed to be, the same rifle that was located in Houston County. And Mr. Brown in this video walks up to his ex-girlfriend and shoots her with this rifle.
And that is shown on the video?
It's shown on the video, but Judge, here's when Mr. Spratt is arguing prejudicial. This video is already on the internet. This video went to the internet before it went to law enforcement in Louisiana. This man was filming from his apartment and posted it on Instagram or TikTok or something. So anybody that wanted to watch this video can certainly already watch it. The public is not going to be learning anything new here, but we want to give Your Honor some context as to these upcoming motions, 5, 6, 7, and 8, as to how things are relevant to the investigation in this case. And I think this video, when you see the other additional proof, will be apparent.
Mr. Spratt, I'm going to allow the playing of the video, and I'm not going to stop the live stream from it because of the simple fact that it is a public proceeding, and any potential juror that would have seen anything about this would be disqualified anyway. So we will proceed with that and
Judge, I'd ask to have the video authenticated then before it's played.
Authenticated.
Yes.
Well, it's not being introduced as evidence at this point. It's being introduced as a basis for, if before it would come before a jury, then yes, I would agree with you. But as far as authenticating it for the purposes of this hearing, I will overrule your objection and allow it to be played. We need to turn the lights.
Bro, the lady just got fucking shot outside my crib, bro. Oh my fucking God, bro.
All right, thank you. Turn the lights back on. So, Judge, this video has nothing to do with the PowerPoint that we're showing. This video ultimately is going to what Mr. Spratt is arguing under the enhancement issues. What you have just seen is a first-degree murder in New Orleans. As corroboration of that, this rifle was recovered in Houston County and ballistics testing was compared. So we have the same weapon that was used to commit a murder on June 27th of 2022 in New Orleans, and then an attempted first-degree murder in Houston County on the same day, June 27th of 2022. Same weapon, and those orange shoes that you saw in New Orleans on the feet of the man in the video were recovered in a shed in Houston County. So again, arguing one of these motions, specifically the enhancement motion, the state has never offered any plea in this case, except to the maximum possible punishment. And now the court knows why. Because the man committed a murder.
That's my motion that he's arguing before I've even had a chance to argue that.
Well, and I would have to agree with Mr. Spratt there, General, that what we're essentially dealing with at the moment is the number 6, I think it was, that we were on, and that's the use of the debarring evidence from U.S. Marshals and New Orleans Police Department. Okay. So the question that I have in regards to there was a prior order that went down that said that we're not going to get into your case in chief as to the basis for, or that the crime committed in Louisiana in your case in chief in this case.
That's correct, and we're not.
Okay.
We're not going to show this
video. What relevance then would this video have in your case in chief, if any?
Only in rebuttal.
Right. So we would have in rebuttal and go to the notice of enhancement.
Yes.
And those are the only basis for it?
Yes. That is the crime scene, though, that's reflected in the PowerPoint. Right. That's what I was trying to provide the court with some context, is that was the original pin that was dropped on Mr. Brown's phone, was on that sidewalk where he can be seen with this rifle. So, and that's kind of why I asked which motions am I arguing when I first stood up, because these are all kind of interwoven and blended the way that Mr. Spratt has drafted them. I'm going to be making essentially the same argument in all of them, but I can wait and argue the enhancement.
I don't want to cut him off from making his argument.
But going specifically to motion number 4, I've already argued that as to why it's relevant and should not be barred. The PowerPoint will have no reference to a crime or a homicide in Louisiana. It will simply show the triangulation of points that Mr. Brown covered in about a 12-hour period, which is very relevant. I mean, for the identification of the defendant in this case, where he just say, well, I was in Louisiana all day. I mean, there's so many reasons why this is relevant, but then going to number 5, we agreed already to that the case is extended and complex. In motion number 6, the state will agree, we're not calling any witnesses from the U.S. Marshal's Office or the New Orleans Police Department in our case in chief. So number 5, essentially, we are agreeing to that. I think it specifically asked to bar the testimony of any U.S. Marshal or New Orleans Police Department witness, and we're agreeing to that in our case in chief.
All right, well, let's go back. Let me hear from Mr. Spratt about number 4 on the PowerPoint. We had kind of skipped over that. I think we'd gone to number 5. You were essentially telling me what you had thought was agreed upon, and number 5 was everybody agrees on that. Number 4 is the PowerPoint presentation. And do you have any additional argument other than the fact that it shows he was from out of state?
I do, Judge, because I've filed other motions in anticipation. He agreed to that. And they have no intentions of abiding by that court order. It's clear. I'm not even on any notice when we get into motion 7 here in a minute. I'm on no notice, Judge, that he intended to use that as an enhancement. And now it would be my assertion that he's played that to this court to try to wedge into the enhancement motion that I filed. That's a clear breach of a court order. And he did. They talked in their response about that, about how they didn't make a plea offer other than the max. Your Honor.
Well, the court order says that the state shall not introduce proof of the defendant's prior bad acts regarding an alleged second-degree murder in Louisiana in their case in chief. And what he has just stated is he doesn't intend to introduce it in his case in chief. He has demonstrated this video for purposes of showing why the PowerPoint presentation showing that is important. I have questions about, for example, how are you going to exclude evidence of the fact that the defendant was identified by Louisiana authorities?
Judge, he said he had other identifying, he has other ways to identify that the defendant was in that vehicle. It's cumulative presentation and the danger of unfair prejudice. Now we've sent that interview out on our YouTube channel to the entire jury pool, and there was no need in that.
The entire jury pool does not watch. If you wanted to come down and with me when I address the jury that's coming in Thursday morning, you will find that there's probably not one of them that has watched the YouTube. So trust me, I'm not as popular as you might think.
Well, you are at my house, Judge.
But you may watch it because it's your life and the kind of things that we do, but not everyone else does. Well, I understand what you're saying, and again, that's no different than having an article in the newspaper, which we've dealt with for generations, and an article on television, which we've dealt with in substantially the same form. There's no difference between that. If someone has watched a YouTube channel and seen something about a case, then they can be questioned about that, and that will be a necessary question for jurors who are coming in. And the way we handle it will be no different than any other pretrial publicity. Have you read or seen anything about that, including any broadcast on the YouTube channel about this case? If you have, don't repeat what you have said. Just tell me, has that caused you to form an opinion one way or the other about the defendant's guilt? And frankly, if they've seen this video, then I would excuse them from the jury more likely than not, because I think it would be highly prejudicial. But at this point, the fact that it was played is not, in my opinion, anything that creates havoc in your case or creates any sort of problem. The question that I have is that why, if the state intends, and again, you can't limit the state on what they want to do unless it somehow prejudices your client. Your client is not from Houston County originally, is that correct?
He is not, Your Honor.
Then obviously it's going to become known at some point that he's not from Houston County. And at that point, then the fact that he's identified as leaving Louisiana, coming up without any reference to any criminal activity is, in my opinion, not anything more than an explanation of how he ended up in Houston County.
Well, Your Honor,
I don't see how it prejudices your client.
Well, respectfully, Your Honor, when the agreed order was entered, I get this PowerPoint that they intended to use that in their case in chief. And now they've backed off of that. So I had to file a motion. So that triggered me to file motions for 6 and 7. I just don't, the general said something about it being relevant to Mr. Brown's location. They can do that without backing up all the way to Louisiana. And the defendant's credibility, I would understand that if I put the defendant on the stand, which is a determination that the defendant and I would have to make.
I think they're talking about the so-called confession that corroborates his confession.
Well, I think the state has enough evidence if they want to establish his identity without doing that. And I would just ask that Your Honor, the state's purpose is to try to establish judicial facts for a court in Louisiana. And that is their bigger concern in this case. That's why.
Repeat that.
I believe the state's purpose is to try to establish judicial facts in Tennessee that can later be used in a courtroom in Louisiana. And there's no relevance to that. There's no relevance for that at all. It's cumulative presentation of evidence when they can do that other ways. He just got through telling you they're trying to link a gun to here and this and that and the other. And why? Why? He stands accused of crimes that occurred in Houston County. It can be tried. But all of this other stuff going into Louisiana, it's clear that they have no intentions of abiding by the court order that they agreed to.
Is this being introduced in their case in chief?
Yes.
Oh.
The cell phone.
The PowerPoint, yes.
Yes.
But that is not evidence of bad acts. That's from what I'm told is that the PowerPoint is simply going to demonstrate his location in Louisiana and where he went from that point and ended in Houston County. And so number one, I don't see how it prejudices your client because of the simple fact that it's clear he's not a resident of Houston County. So he's got to come from somewhere. There's no indication if that crime scene is removed. There's no indication of where that is. It's no different than tracking someone's location, especially since there was a manhunt for the defendant. My opinion is that this PowerPoint presentation with the redaction of the alleged crime scene, and if there's no reference to a criminal investigation in Louisiana in that PowerPoint, then there's nothing that prejudices your client any more than having an officer testify that he later said he was from New Orleans or wherever and was found in Houston County. I just don't see the prejudice to it. And as a criminal defense lawyer and my history of being that, I would like many times to try to limit the state's proof on what I'd like for them to be able to show and not show. But it only rises to the level of prejudice to your client that allows us to exclude something that is otherwise their tactics or their procedure that they want to do. I do not find, as a matter of law, that this PowerPoint presentation with the removal of the crime scene location, that a simple PowerPoint presentation of the location of the defendant in Louisiana and tracing his movements to end up in the spot where the case took place is prejudicial to a client. I found it to be relevant because of the fact that there was apparently left the scene and that my understanding was a manhunt. And although there was a supposed statement whatsoever, it goes to show the identity of the defendant as being moving from that point to this point and where the crime scene occurred.
Judge, briefly, I do believe that may be a misunderstanding. He didn't have those cell phones after this crime allegedly occurred. Law enforcement's had those the whole time. So there's not going to be any evidence that shows him moving around during this manhunt with these cell phones. That there is none of that. So I don't know if that changes the court's opinion. And I would say that I'm sorry.
It doesn't.
Okay.
All right. So number 4, we've ruled on that the PowerPoint is admissible with a simple removal of the crime scene, and there'll be no reference to criminal activity, but rather it's just simply showing his movements. Number 5 was agreed upon. Number 6 and number 7, which is what you were about to argue, I think, when General Crouch, at my request, stepped up and started arguing about it. And there was some indication that and what Mr. Crouch is saying is they will not call any witnesses to testify. Anyone from the U.S. Marshal's office or from the New Orleans Police Department will not be called during the case in chief, but would only be reserved for rebuttal. And number 7 is the motion to bar testimony of Aaron Hatfield, which obviously is a different matter, but you want to address anything else about number 6?
No, Your Honor. I believe as stated in the email and listed on the docket notes, I think we can enter an order on 6 and 7.
6 and 7, they're not intending to call a witness from the police department in New Orleans or from the U.S. Marshal's office in their case in chief, but are reserving the right to call them in rebuttal if necessary. They're not calling Aaron Hatfield as a witness in their case in chief, but are reserving the right to call him in rebuttal if that was necessary. Is that correct?
That's correct, Judge.
Then we now have it of record. So that moves us then to number 8, which is a motion to bar the state from seeking an enhanced punishment or in the alternative to continue the trial.
That's correct, Your Honor. Your Honor, I don't know if the court's had a chance to familiarize itself with the motion. Judge, interestingly enough, in the state's response, as the court had time to review the state's response.
I've read that
It was
too.
filed yesterday.
what I do
My
during my
motion says
lunch
that
hour.
I don't take notice with the timeliness of the motion. That may have been misstated in my motion because I'm saying that the motion they filed put him on no notice at all. Simple generic terms like possession of methamphetamine, possession of marijuana, those don't comply with the statute at all. So to this moment, I would say that the time requirement hasn't been met. So perhaps that motion was, or perhaps that issue was misstated in my written motion. There was a document filed since the filing of that document. The state has provided me with some records just yesterday from Louisiana. I only see one document in here that's signed by a judge, and that would be a plea form potentially of some sort to a domestic assault conviction. But the bigger issue I have here is that if we're ready to go to trial, I don't think they should be able to range him up based on that notice that they sent me at a sentencing hearing. And if so, I think I have to. It was incumbent upon me, or I would waive the issue to file this motion. I think State versus Benham, I've had the defendant's criminal record. I don't know if the court's had a chance to review Benham.
I've read Benham.
Right. But it places an affirmative burden on the state to expressly notify the defendant of its intentions regarding sentencing. I knew of nothing about a range up until last week, and that was, I can't recall if it was General Turnbow or General Krause that I talked to, but I knew nothing about any intention like that, of them to do that. And then they filed a completely defective document, which is an outline that doesn't comply with the statute. And now they say, well, we've pulled a 51-year plea offer. Well, that's great, Judge, because they can't get 51 years out of him. We all agree on that. They're asking me to try to commit malpractice. He's entitled to be noted. He's entitled to notice of what he's facing. It affects trial strategy. That's what Benham says. It affects everything. He could change his plea. I don't know. Can't do it now if you don't know what you're doing. So General Crouch sent me a plea offer by email, August the 30th, that was dated May the 26th. May the 17th. I get that by email on August the 30th. Now, Your Honor, as of Friday, my understanding is the state doesn't have a conviction that can even support count 6 of the indictment. So I don't know how in the world, I believe he has an absolute right to know what he's facing. So one, based on the general's statements to me, I'd ask that count 6 be dismissed. And two, either we go to trial and we go to trial Thursday at range 1, or I want a continuance. And if I get it, and if it's a continuance, I believe ethically I had to do that. I filed one motion only in this, well, I filed a motion to change venue, a motion for a forensic evaluation, and a motion regarding New Orleans. Simple case. The state set on this stuff. These documents that they requested in the court, they weren't even requested until September 18th by somebody. That I just, if it's continued, Judge, I would ask that it be continued until March to take into account counsel's professional livelihood, personal livelihood, and everything else. Because I feel like all we've done in this case is play games with New Orleans instead of try a case in Houston County. So he's not on any kind of notice. So I do think the timeliness, whether I misstated it in my motion or not, I still don't think I'm properly on notice in compliance with the statute. So whether or not that relates back to a Rule 12B error on their part, I would say that it does, because even the notice that was shot down in Benham and the sentence is returned and resentenced at range 1 on all counts, that was more effective than what I've got. I don't have anything. I have one document signed by a judge, and it's a plea form. So I can't tell him what he's facing unless we go at range 1 or we continue. And so I would ask the court to make a ruling on that. I am prepared to go to trial Thursday, but if the state's going to be allowed to range him up, Judge, then I would object.
The range goes to sentencing.
It does, Your Honor.
It doesn't go to the guilt or innocence phase.
It does, Your Honor, but the Benham case says that it goes directly into potentially trial strategy.
Right.
Like I said, had I taken one of the pleas that he offered, I'd be up there in front of the board in trouble. So, I mean, I don't think they can get what they've asked for. And I don't think it's fair for Mr. Brown could change his plea and not know what he's done. So I think he's got a right to at least be put on some sort of proper notice. In simple terms that don't comply with the statute, some of those things don't even have dates on them. I could be walking into a hornet's nest at a sentencing hearing. That's a complete denial of due process, Judge. And I'd ask if we go, and I am ready to go. If we go, I would ask that we go at range 1 or we continue to the court's March docket. And that I would ask the court to choose one of those options or let the general choose one of those options. It doesn't matter to me, but I just think that one of those options needs to be the outcome of that motion.
Judge, first of all, the state has never offered anything to Mr. Brown except the maximum punishment, whatever that may be. And we wouldn't know what the maximum punishment was until we get to the sentencing phase. The state is required to do our best job at noticing the defendant that we intend to seek an enhanced range or enhanced punishment within a range. And that's what we've done. And our pleadings and filings more than meet those requirements. But let me give the court some context. The initial offer of 51 years was extended, and 51 years in May of this year was the maximum punishment we calculated that could be given as a sentence to the defendant, and that assumes that the court were to employ consecutive sentencing. I mean, that's up to the court. So again, we noticed him or sent an offer of 51 years. We did change that offer because in our research of Mr. Brown's prior felony convictions out of the state of Louisiana, we had to compare the elements of crimes in Louisiana to the elements of crimes in Tennessee.
This has actually come up in several trials in the past. When you have charges that have the same name, but they have different meanings or different requirements to meet those charges. And when you're trying to bring things over and compare them one for one, especially when you're doing sentencing guidelines, when you have that big chart and numbers and everything, it gets all confusing, and it's quite a bit of work to figure out whether the prior charges meet the guidelines for your charges in your state. And then one state will have assault and battery. Another state doesn't have assault, it only has battery, it only has assault, and they both mean the same thing, and it gets super confusing.
So right out of the gate, we knew that one of the prior felony convictions would not meet the requirement for count 4, which we had charged. So we dismissed count 4 already. Now, Mr. Spratt is alleging that we can't meet count 6, but Mr. Spratt already knows is that I am dismissing count 6 because the prior felonies in Louisiana are not the requisite prior felonies required in the elements of proving count 6. So count 6 will be dismissed, and he already knows that. Now, 45 years is the current offer, and we went through the prior felony convictions from Louisiana, and that is our best guess at the maximum that Mr. Brown can be sentenced to. And that's assuming that the court runs things consecutive, which we don't know if he will or not, if he's even convicted. Point being is there's been plenty of notice given to the defendant. First of all, one, if you look at our actual notice of impeachment and range of punishment, it is very detailed. Some of the things that are missing are conviction dates, which we have tried to amend. We literally went to Louisiana. Traveled to Louisiana and went to multiple parishes, Orleans Parish, St. James Parish, and St. John's Parish, to get certified copies of these judgments. And I can put on proof through investigator Etheridge if the court wants. Their judgments are different than the judgments in Tennessee. They're called Boykin pleas. And we can talk about the legals of that. But big picture, that's up to the court at the sentencing hearing to determine whether we have met our burden of ranging him up on each specific count. That's the defendant is asking you to essentially tell him what your decision will be at sentencing if he's convicted. I mean, the cart is way ahead of the horse on this thing, way ahead of it. We have provided Mr. Spratt with certified judgments of prior felony convictions that we obtained from the state of Louisiana. There is no more proof that we can put on as to what we anticipate his maximum punishment can be. We've done all we can possibly do.
Can I briefly respond again? And I believe, and if I misspoke earlier, I'm sorry, but I mean, I do understand that they're going to dismiss count 6, but that's concerning that you indict something that you didn't have the proof for. He's been sitting here indicted. That was a Class B felony, and now they're saying, uh-oh, we don't have any proof. That concerns me, and what concerns me is looking into this, some things, there could be some more. Judge, I feel pretty strongly that notice does not even come close to complying with that statute. It does not say what the nature of those convictions are. There are some that are missing dates. There are several that don't have court dates. I have some things that at one point I spoke to them last week. They thought there might be a felony marijuana charge. Well, I get that. It's whatever that is. It appears to me to be certified copies of docket minutes from the court. None signed by a judge other than a plea sheet that I've seen. But last Friday, just as early as last Friday, they thought there was a felony marijuana conviction, and that says clearly 14 grams or less, which is not a felony here in Tennessee. So, I mean, I just feel like that statute was just not even close to complied with. So, I mean, we just asked if he were to decide, this goes deep into trial strategy, and he's entitled to be put on notice of what he's facing. I realize you might not be able to change that at a sentencing hearing, and they've got to get a conviction first. I understand that too. But for me to go into a trial and not be able to tell him what he's facing, that begs the question as to whether or not I'm competent to represent him, and it begs the question as to whether or not he's got post-conviction relief issues if there is a conviction when it's over with. So, I mean, I would strongly request the court to either we go at range 1 or we continue it. I don't think there's any other way that I can effectively represent Mr. Brown.
Judge, ma'am.
I'll give you both sides. It's Mr. Spratt's motion, so he'll have the last say, but you certainly can address it.
I just want to respond to one thing. For example, count 6, based on our research and the criminal history of Mr. Brown, we thought we could prove that element of the crime in count 6 and 4. Again, we met with an assistant district attorney in Louisiana to get an interpretation of their statutes.
Louisiana is under the Napoleonic Code. Their entire legal system is different than ours. So it's not surprising that there could be some differences in the I say they're under the Napoleonic Code. That's the basis upon which their system is different than ours.
And that's what I wanted the court to know. We didn't indict him in bad faith. We literally had to get legal advice on the interpretation of the Louisiana law. I'm not obviously not licensed to practice law in Louisiana. So we had a lawyer, a prosecutor licensed in Louisiana to help us interpret and show the equivalence to our crimes. And therefore, we dismissed count 4 and will be dismissing count 6.
Mr. Spratt?
He doesn't have a lawyer in Louisiana. I'm certainly not one. So if they've had the opportunity to do that, then why shouldn't he get the opportunity to have a Louisiana lawyer or at least consult with somebody? I mean, I don't know when they had time to do that, but if they had time to do that, certainly they could have put me on some sort of proper notice.
The question that I'm dealing with here is basically whether or not the state's notice of enhancement complies with 4035-202 of the Tennessee Code, which is basically the section that requires the notice of enhancement. Let me make sure that hasn't been. All right. And that section provides notice of intent to seek enhanced punishment, statement of enhancement and mitigating factors. So first part under subsection A says this: if the district attorney general believes that a defendant should be sentenced as a multiple, persistent, or career offender, the district attorney general shall file a statement thereof with the court and defense counsel not less than 10 days before trial or acceptance of a guilty plea, provided that notice may be waived by the defendant in writing with the consent of the district attorney general and the court accepting the plea. The statement, which shall not be made known to the jury determining the guilt or innocence of the defendant on the primary offense, must set forth the nature of the prior felony convictions, the dates of the convictions, and the identity of the courts of the convictions. The original and certified copy of the court record of any prior felony conviction bearing the same name as that by which the defendant is charged in the primary offense is prima facie evidence that the defendant named in the record is the same as the defendant before the court, and is prima facie evidence of the facts set out in the record. It does not require that a certified copy of the convictions be attached to the notice. The notice that is set forth is only requiring 3 elements. 1, it must set forth the nature of the prior felony conviction, the date of the conviction, and the identity of the courts for the conviction. In the Benham case that Mr. Spratt has referred to and relies upon, the Supreme Court in 2003 found that the notice or purported notice that the district attorney's office gave was insufficient because of the fact that it was not formed in a separate pleading, but rather in discovery. And in the discovery, if I recall the statement of it, that the discovery said, well, with the defendant's the defendant, based on his overall record, is a career offender. That was it. That was what the district attorney's office said. The state then attached to the discovery response a photostatic copy of the defendant's record of criminal offenses. The record contains the charges, the identity of the courts where the conviction occurred, and dates of disposition. But it doesn't give any sort of indication as to the nature of the convictions. So by statute, the district attorney general notifying a defendant of intention to seek enhanced punishment must set forth 3 items. This is from the Supreme Court: nature of the conviction, the date of the conviction, identity of the courts of the conviction. And that is what was there. Although the Court of Criminal Appeals stated that it appeared to contemplate the filing of a separate notice, it went on to say that that was sufficient. The Supreme Court said, no, we think they have to file a separate notice, and that separate notice has to be formed or has to be identified that it is a notice of impeachment or range of punishment. So as opposed to the Benham case, in this case, 10 days prior to the trial, the state has filed a notice of impeachment and range of punishment. It was timely filed. The defendant even acknowledges that. And in it is styled a notice of impeachment and range of punishment. It then goes on to list 16 prior convictions of the defendant. It does go on to give in the first 11 of those convictions gives the nature of the offense, what it was, the court or the area where it was located, and the date of the conviction or the date of committed. And Those 11 comply with this court's opinion with the statement that the statute provides, as well as what the Supreme Court in Benham said is must be given. Number 12 says he was convicted of the offense of resisting an officer in St. John the Baptist Parish, Louisiana, in a case number, but it doesn't have the date. Neither does number 13, number 14, number 15, and number 16. None of those have an actual date unless you count the date number, the date somehow being the case number, which this court finds is not sufficient. So this court's of the opinion that the 11, 1 through 11 of those prior records on the notice of enhancement, impeachment rather, and range of punishment would be in fact complying with the statute, and therefore would be timely filed. It would be evidence that it complies with the statute. And for that reason, the defendant's motion to exclude that and proceed as arranged 1 is denied. He's, number 1, he's going to trial on Thursday. I'm not going to continue the case. It will go to trial on Thursday. Mr. Spratt has done an admirable job in getting this case ready. He is very obviously impassioned in his defense of the defendant, and I expect nothing less than that. Mr. Spratt's a very capable attorney, and the fact that he may disagree with this court's ruling, he may disagree with the state's position in the case, but it does not change the fact that he is prepared for trial. Those prior convictions are admissible under both State versus Benham and the state statute or notice of impeachment and enhancement. And as a result of that, the motion on rule number 8, I guess it was, is respectfully denied. Is there anything further on this case? And we are ready for trial on Thursday. We will begin jury selection at 9 o'clock. Thank you.
All rise. This Circuit Court of Dixon County is now in session. The Honorable Judge David Wolff presiding. All you had visit before this court, draw nigh and you shall be heard. God bless the United States, this state, and this court. You may be seated.
All right. We are ready to take up the issue of the State versus B.J. Brown. We're going to bring up Mr. Brown. All right, this is was scheduled to be the trial date on the attempted first-degree murder charge. As of late yesterday afternoon, the case was continued by agreement with the state and the defense based upon some information that had just been delivered, not made aware of, but I think it was information that is salient to the defense that needed more time to try to resolve the issues. So we are now looking at trying to set a new trial date. Our next term of court is in March of 2024, and unfortunately we have pretty well already filled the month of March here in Dixon County with significant trials. We have the 30th and the 30th and the 1st, I'm sorry, the 29th and the 1st of February, 29th of February and the 1st day of March. We have set criminal trials here in Dixon County. On the 4th, we have the circuit civil docket call. On the 5th of March, we start Ricky Allen Hughes, attempted first-degree murder. That's with Mr. Flanagan and General Allen. Then we have on the 6th, Haley Brown, the vehicular homicide case. That's your case, correct? And that's scheduled to potentially go through the end of the week. And on the 8th, I think is General Arnold may have some additional cases. On the 11th, 12th, we have a criminal docket call. The 13th, we have State versus Pollard, which is a rape trial. Is that Ms. Smith's case, if I understand it correctly, that we had motions on? And it's been continued a number of times, so it's going to have to go. And then Friday the 15th is the DUI day, if I recall correctly. The 18th is Chancery Day, then the 19th through the 21st is supposed to be the Judicial Conference in Murfreesboro. I'm not really supposed to say where it's supposed to be, but in any event.
We'll be there. Thanks for the invitation, Judge.
22nd is the Howard Hogan drug case. Then we go to the 25th and we have criminal trials, Robert Capes and some others that are set behind it. And then we have VOP Day on the 26th, 27th. 28th is Chancery, 29th is Good Friday, and that is it. We have filled up a lot of the month of April that would normally be in Humphreys County with criminal trials here in Dixon. The Circuit Civil Docket call on the first day of Humphreys County, first day of April is a Humphreys County Circuit Civil Docket call. And then I have a will contest set on the 2nd here in Dixon County. Then we have Chancery on the 3rd and 4th and 5th in different counties. Then I have a criminal docket in Waverly on the 8th, and we start the 9th through the 12th criminal trials in Waverly. And then we have Paul Garrett starting here in Dixon on the 15th, and backing that up starting on the 18th and 19th is the State versus Travieso, which is a second-degree murder case that was continued from Tuesday of next week. And then we have criminal trials in Dixon again on the 22nd and 23rd. Then I have Humphreys County violation of probation on the 24th. Then I have the 25th and 26th as Chancery, and the 29th and the 30th, we said again, criminal trials, and that one is Watson Thomas, an aggravated rape case. So, anybody have any suggestions?
Yeah. Your Honor, as the court is aware, this case originated in Houston County. The venue has been transferred to Dixon County, but I think it would be appropriate to use a Houston County trial date for this case. I know the folks in Houston County, prosecutor and the sheriff and all would be happy to move some of their criminal cases and let this case take its place.
Well, I have December the 12th through the 14th as criminal trial dates in Houston County.
And the state would be ready to go by December the 12th.
There's a logic to that, Mr. Spratt.
There is, Your Honor, other than I have, and I'm not sure the exact amount, but I believe I have 10 cases set for trial with Judge Wallace in December. Some of those are very serious. Some of those have age on them that I need to address those. So, I mean, December's there's
what
a rape trial that's set on a retained client that's about 6 years old, maybe 7.
When is that set?
It's set December 7th, I believe. I'm sorry. Set right now, December 8th. I have sentencing hearings set in Houston County. I have trials set the following week in December in Humphreys County. I have an aggravated sexual battery set on December the 12th in Humphreys County.
And who is the judge in Humphreys County?
It'll be Judge Wallace in December.
I think I can help you with that situation. This case, in my opinion, would take precedence over any of your other cases. And if I can, we'll take a break and I'll contact Judge Wallace and see if there's any problem with that. I do think it is important to try to get this case heard and decided, and I don't mind giving the continuance yesterday as we discussed for the basis for it. Turnbow?
Yes, Your Honor.
Stewart County is your bailiwick. What are we looking like for trials in Stewart County in the month of November, starting through say the 14th through the 17th? I'm showing our trial dates.
It is, Your Honor. Let me pull up the trial schedule right quick. I mean, we do have some cases that are a little older, Judge, that need to be tried, but no one that I'm seeing is incarcerated. We have some cases that are a little older that need to be tried, but I'm not seeing anyone who's incarcerated on older cases, so.
All right, well, let me see the counsel in the jury room across the hall. I'd like to bring your calendar and let's see what we can figure out.
All rise.
Well, I thought there's a head down there, and I know it's not, I didn't think it was Pam Billingsley, but I thought she was on the screen here, so wanted to know whose head I was looking at.
She come in to do that, so I wouldn't have to run around.
Good.
Can you just say the very tip top of my head? Yeah.
All right, after a thorough conference with lawyers involved in this case, we are going to, instead of trying to move this case to March, we're going to expedite it and move it to January the 23rd through the 26th will now be the new trial date. It will be here in Dixon County in this courtroom. In addition to that, we are now setting some additional motion days. A status day or a motion day will be on the 9th of November here in this courtroom. That will be after the Paul Garrett rape motions on the 8th. We also have a sentencing hearing on State versus Tomlin that day. But Mr. Brown's motions will be heard on the 9th at 9 o'clock. We're going to have Mr. Brown transported on the 8th so that he can be here and meet with his lawyer in advance of those motions, and have him here on the 8th and 9th for those motions. In addition, then, in the month of December, when I would normally, this is originated in Houston County, and my Houston County docket is going to be on the 11th. So at 1:30, I have a status on the State versus Stephen Wiggins regarding the motion for new trial. We're going to set a status day in this case for the 11th of December. All of this, Mr. Brown, for your information, is designed to try to expedite and make sure that everything that needs to be done in your case to get ready for your trial in January is being done, and that there aren't any glitches like we've had this time, okay? So all we're trying to do is to make sure that we keep it on track and that it will not be continued from that January trial date. So we're going to trial on the 23rd of January. With that being the case, then, so we have 3 new dates. The 9th of November, and I'm sorry, we're going to need to transport him, I believe we said on the 8th of, was it the 8th of December, and have him held through the 11th. And then on the trial, we're going to need to have him transported from the Department of Corrections on the 18th, and then hold him through the trial at that point. And we're going to do an order for the Captain Davis. We're going to do an order that will reflect all of those days we need him transported. But that's all in an effort to expedite and assist Mr. Spratt in trying to communicate with Mr. Brown and make sure that everything's being done accordingly. Anything else then, with that having been announced on the record?
Just briefly, the motions from Tuesday, the orders for those, do those need to be, I guess since I've stood up and raised the issue, I'm kind of volunteering that I'm going to have to draft those.
Well, I know you've got a full plate with some other things. Is there any reason that those motions couldn't be done by the state, or the order on those motions couldn't be done by the state, Mr.
We'll be happy to draft orders on Mr. Spratt's motions.
Well, if they're your motions, then logically they would be an order that you would need to draw. So.
We can do them, Judge.
Well, you two talk. I don't care who does it. I just want to do it. Being in private practice by himself, or even if he's in Baker Law Group, it is a situation where he doesn't quite have the same advantages that perhaps your office has. So y'all talk about it. I don't care who does it. I just want to make sure they get done. I do think a written order reflecting that ruling is clear for the record, and it's an advantage. Then is there anything else with this case then before we adjourn? Pardon?
The December 11th date, when do you want to transport it?
On the December date, we need him transported on the 8th to have him housed here in, is that correct, the 8th?
Yes.
All right. 8th of December will be the day we need him transported here so that Mr. Spratt can talk to him that afternoon. and be ready for the hearing on the 11th. And then he'll be transported from the Dixon County Jail to the Houston County Courthouse, where that hearing will take place at 1:30 on the 11th. All right, anything else?
It's all from defense, Judge.
All right, then we'll hopefully, everything will be now in place to carry this on through and have it tried in January, and we'll be adjourned for the day. Thank you. We
All rise.